information on the information you elect to share with us. And so we'll talk again about what does that look like. The auctions close on the 20th. We'll immediately begin the evaluation process, and by the 30th, announce the winners. We're recommending that for those of you who are planning to apply for a liquor license and go into business as soon as June 1, that you have your application ready and ultimately submitted immediately upon notification that you've won the auction. As soon as May 1st, you should be submitting your application for the liquor license. If you do that, and if you do so accurately and completely, providing you meet the qualifications as set forth by the licensing division, you will receive your temporary authorization allowing you to buy the inventory, allowing you to go into business beginning June 1. But you can be obtaining the application and even beginning to fill it out right now and get it ready to submit on the 1st of May. Or if we are able to announce auction winners sooner, as soon as you've been notified as being the winner, you could proceed with that process. We'll also immediately, for those of you who have expressed the intent and ability to buy inventory, we will issue the inventory contracts. We'll offer those out for the bidders. And by May 7th, the auction payment will be due, and by the 11th, the initial inventory payment will be due, 80% of the projected inventory value, with the balance due on the 15th of June. Okay, so those are some key dates that are approaching that we want you to be aware of. Let's talk about the process of evaluation. And again, this is completely consistent with what we spoke about last week, but just really important that everybody understands. This is not simply the high bidder wins. It has to be the high bidder taking into consideration the impact of the bidder's decisions with respect to the removal of inventory and fixtures. So we are going to compare the sum total of the individual store high bids to that of the all system bid. Right now, I believe as of this morning, the all system bid is around $600,000, and the sum total of the individual store bids is in excess of $2 million, like $2.2 million. So certainly at face value, it appears that the best revenue opportunity for the state would to be award the auction to the individual high bids. But to be sure of that, we would still have to look at the established bidder's intent and ability with respect to inventory and fixtures. And the way that that is being determined is based on the information that you submit by the 20th. So we're asking that if you intend to occupy that space and thus assume full responsibilities for those fixtures, you must submit to us a landlord's letter of intent to lease that facility to you. Additionally, if you want to purchase that inventory, we're asking you to submit from your financial institution proof of funds. Since we announced this last week, we have had several bidders bring acceptable elements forward, and so we're pleased to see that both landlords and financial institutions are accommodating these requests for those qualified bidders. So we encourage you to, if you do not yet have these documents and yet intend to purchase the inventory and or assume responsibility for the lease, you only have now less than a week to pull that together and get it submitted to us electronically via email to Kathy McDaniels. It's optional, but as we're going to review again, it has a pretty significant impact in the bid evaluation process. So we want you to be aware of that so that you can make a decision that's in your best interest. The other thing we reviewed last week is specifically how your decisions with respect to buying the inventory or fixtures will be specifically calculated against your bid. You've got options to buy the inventory or not. If you buy the inventory in place, that is really your most favorable approach with respect to your bid value, because we will not devalue your bid at all. If you opt to purchase the inventory off of our back dock, it means that I've got to buy cases and I've got to expend labor to pack that inventory up and put it on my back dock for you to pick up. And so there'd be a $4.21 per case bid adjustment. On average, there's 2,000 cases, and I'll remind you that we have detailed all of this information for each individual store in terms of the estimated inventory impacts and fixture impacts in the bid workbook that's on the website. If you don't purchase the inventory at all, then we will, for evaluation purposes, adjust your high bid by $4.44 per case, because in addition to the packaging and labor expense, I also now have a transportation expense that has to be incurred. And I'll also remind you that this is, in reality, not the fully burdened expense, because some of the expense of bringing that product back to my distribution center is already covered by the suppliers through my buyback agreement. And so I'm only, in these cases, would be charging you for the expense that is not already covered. And then from a fixtures standpoint, on average, there's a $3,000 expense for me to go into those stores and remove the fixtures if you do not establish rights to the property. I can't let you into the store to remove fixtures, and I don't believe the landlords will let you into the store to remove fixtures unless you actually establish the right to be there. And that's really from a liability standpoint. So again, if we do not get a letter of intent demonstrating that you have rights to that property, then we have to assume that we're going to incur an expense of $3,000 to remove that inventory. So one question that got brought up during, brought up several times during the bidders conference last week was around the proxy. Every bidder has the option to establish a proxy, which really works on their behalf so that they don't have to sit in front of the auction continuously to bid in response to a competitive bid. And instead, you can set this proxy so that it will automatically respond to a competitive bid up to whatever your established limit is. So if you're willing to spend up to $10,000 for a given property, as an example, you could establish a $10,000 proxy, which would only be exercised as necessary to respond to a competitive bid. So someone could have a $10,000 proxy, but actually only offer the minimum bid of $1,000. If a competitive bid came in at $1,100, then your proxy would be exercised to $1,200. And that would continue up into the point that your proxy was fully exercised, if necessary. If the competition stopped at $8,000, then you would have remaining proxy dollars that were not used. But a concern was raised, and I think it's legitimate, that since we are looking at the value to the state, taking into consideration any expenses that we incur as a result of your decisions to assume responsibility for inventory and fixtures, that it is possible that the competition does not cause your proxy to be fully exercised, and yet because you do not take fixtures and or inventory, your net bid value is not the best option for the state, and you could lose the auction when in fact, by proxy, you have stated a willingness to actually spend more if necessary to win the auction. So what we've done is provided some clarity here that says, first of all, your use of a proxy is and will continue to be completely optional. And only a competitive bid will cause your proxy to be exercised. However, during the evaluation period, when we apply criteria around the costs of removing fixtures and inventory, if it causes the high bidder to potentially lose that auction, but they have remaining proxy that could offset that potential loss, we would apply that proxy as necessary and only if necessary to secure those auction rights. That way, a bidder is ensured they won't lose an auction due to what we refer to as an unfavorable net bid value when they could have adjusted their bid value with their proxy dollars. I have an example, so let's just take a look at it. You can see how that works. In this particular bid, we have 4 individuals, bidder A, B, C, and D. And you can see by this example that bidder A established a $20,000 proxy. They were willing to spend up to $20,000 if necessary to win this auction. Bidder B had a proxy of $7,900. Bidder C did not establish a proxy, and bidder D had a proxy also of $3,000. And you'll see that those with those bidders C, B, C, and D, if they had a proxy, it was fully exercised. So bidder D had a proxy of $3,000, and ultimately that's where their bidding ended. Bidder C, again, had no proxy. They stopped bidding at $6,000. Bidder B, fully exercised their proxy at $7,900, and bidder A's proxy kicked in, added $100, and at closure there was no additional bidding activity, and so the apparent successful bidder in this situation was bidder A with $8,000. Now we look at the decisions that the bidders have made, and those decisions are reflected again by the intent and ability documents that they elected to share with us during the evaluation period. And in this case, bidder A was planning to go to a new location, which means they cannot assume responsibility for the fixtures. And in this case, they were not planning to buy the inventory either. Well, that means that we're going to incur $3,000 fixture removal expense and an $8,880 inventory removal expense. So although I'm going to receive a check for $8,000, I'm going to have to write checks for $11,880, which means that I'm going to be in the hole nearly $4,000. I compare that option to the other 3 bidders, and you can see that in reality, when you go to bidder D, who offered $3,000, staying in the location, thus assuming responsibility for the fixtures, avoiding any fixture removal expense for me. I also don't have any inventory removal expense because they're purchasing the inventory in place. Their bid value of $3,000 really has a value of $3,000. And in this case, based on a net bid value, appears to be the best deal for the state. However, we go back to the proxy and we see that bidder A was willing to spend more if competition required it. Bidder A was willing to spend up to $20,000 to secure this right. However, it wouldn't take the entire $20,000 to do that. What it requires is bidder A needs enough proxy to make up the difference between their unfavorable net bid value of $3,880 and the most favorable net bid value of $3,000. In other words, there's a difference of $6,880 between their offer and the offer that is most beneficial to the state. So in this situation, bidder A would be required to pay their original bid value of $8,000 plus the difference between their unfavorable net bid value and the most favorable net bid value, which is $6,880 plus $100. In other words, it has to be a better deal, not just as good of a deal. So we wouldn't require bidder A to expend their entire proxy, merely enough to offer a better deal to the state based on what they established their willingness to do in advance of the auction closing. So this is an important clarification for you to be aware of so that you can determine when you want to use a proxy and at what value you want to set that proxy at. I'm going to pause a moment so that Cheryl has a clarification she wants to provide for those participating.
I'm going to be typing something into chat for people who are trying to call in. I'm going to tell you the number and I'll type it into. It's 1-877-668-4493 for those of you who are having difficulty accessing the internet phone line.
So while Cheryl's doing that, we'll continue to talk, but I'll repeat what she just said. If you're having difficulty with the internet phone line and you want to use a hard call-in number for the audio portion of this conference, you can call 877-668-4493. So some important dates coming up. Again, your deadline for bid deposits is the 19th. That's next Thursday. We need your evidence of intent and ability before the auction closes next Friday, the 20th. We'll immediately begin the evaluation process on the 23rd, and no later than the 30th, we will announce the bid awards. You can apply for your liquor licenses immediately thereafter. We'll also offer the inventory contracts forward. Your auction payment is due on the 7th, and your inventory payment of 80% will be established and due by the 11th with a balance on June 15th. So I want to go, of course, we've got the ongoing links for additional information that we encourage you to use for both the auction as well as for licensing. We'll post this presentation as we have in the past on our website, and I want to go now to address some of the questions that are already coming in, and we can answer questions on any of the material I just covered or anything new that you might have. So if you just give me a moment, I want to review the chat log here, and we'll start from the top. And I also want to encourage you that you listen carefully to the questions that we are fielding so that we minimize duplicate questions. And if I see what appears to be a duplicate question in the chat session that I've already answered, I will move on to the next one. Okay. Okay, so I see the first question I'm going to answer. It says, if the buyer does take the inventory and existing store, will they be reimbursed? I don't think I actually understand that question. We will not be reimbursing anybody for purchasing inventory from an existing store. There's a different fee schedule associated with where you buy the inventory. If you buy it in place, you get your best deal. If you buy it off the back dock, that's your second best deal. And if you don't buy it at all, your bid value is most negatively impacted in the evaluation process. Sometimes we cannot reach a landlord but intend to lease the existing store. Again, in order for us to consider your intent and ability to the existing location, you must submit a landlord's letter of intent. If you're unable to do that, we're unable to consider it as a factor in the evaluation process. You do have options, of course, and that is to work with an alternate landlord, and but it will affect your bid evaluation process. Question in the example I gave, would bidder A be the first to be informed that they are the high bidder? Bidder A will be notified that they are the apparent successful bidder. In fact, they will probably see that themselves at the close of the auction, that indeed they were the high bidder at auction close. But it is the evaluation process that follows which will ultimately determine who the auction rights will be awarded to. Question of how do we know what the inventory removal expense is? Again, there is a workbook on each auction page. Kathy, what is the name of that workbook?
Cost avoidance.
Cost avoidance workbook. Look for a link right above the quick stats table. So right above the quick stats table is a paragraph talking about inventory and fixture removal costs. And there's a link called the cost avoidance workbook. And when you look at it, every store individually is listed based on what the projected average inventory levels are. So for planning purposes, you can anticipate what that expense would be. How soon can we submit an LOI if we have them? Where do we state that we are purchasing the inventory? Okay, so you can submit your LOIs immediately via email to Kathy McDaniels. The way that you state that you're going to be purchasing the inventory is you simply provide proof of funds. If we get a letter of intent from the landlord and no proof of funds, our assumption for evaluation purposes will be that you will assume responsibility for the fixtures and we will avoid a $3,000 fixture removal expense. However, without the proof of funds document, we will assume you will not be purchasing the inventory. On the other hand, if you submit a proof of funds document, but not a letter of intent, we will assume that we're going to incur a $3,000 fixture removal expense, but that you will be purchasing the inventory off of our back dock. And again, I'll refer you back to the slide in this presentation, which shows you the various charges, but it's $4.21 a case if you buy it off our back dock, that we will adjust your bid for evaluation purposes for $4.44, I believe, if we have to send that back to our DC. And those are the costs that you'll avoid by just buying it in place. But again, if you have these documents, you can submit them anytime up to the 20th of April, but not beyond that. Another question, so we can win the bid, purchase the inventory in place, establish property rights, and still not win the auction. No, I don't think so. I think that if you are the apparent successful bidder, in other words, if you are the high bidder when the auction closes, and you are purchasing the inventory in place because you have demonstrated a letter of intent and proof of funds, there is no other evaluation process that we're going to go through which would change the outcome. You indeed would be notified as the winner. It's only when you do not provide proof of funds or a letter of intent for that location that it could change the apparent successful bidder to something else. Question is, on April 23rd, which bidder would be given the right of refusal? So, I'm not sure I understand that question. So, yeah, there is no refusal. If you won the auction, you've actually won the auction. For some reason, we're not able to arrange a lease. Can the new location be less than 10,000 square feet? Yes. What you're bidding on is the exclusive right to apply for a liquor license at the existing location within its current square footage. However, if you're unable to reach agreement with the landlord, you can request an alternate location within a 1 mile radius of the existing location, and that new location may operate at less than 10,000 square feet. Even if you stay at your existing location, you are not mandated to maintain the existing square footage. You can make it larger or you can make it smaller. What you're really getting is the privilege and the special exception to the law of operating a liquor retail outlet less than 10,000 square feet. Questions about trade area. As you are aware that there will be additional definitions and rulemaking by the board with respect to trade area. And the trade area is a provision mentioned within the new law that suggests there may be communities in the state that are not adequately served after all the dust settles. So when all the new big box stores are in place and the contract liquor stores have converted and the state stores have been auctioned off, if there is a community that is not adequately served, the board will have the authority to designate additional exceptions to the 10,000 square foot rule and allow for an additional liquor store to operate in that smaller footprint. Those rules by the board have not yet been established and won't begin that work probably till June. But what I can share with you is that we expect the board to be conservative in their rulemaking. There's already applications for spirit retailers that will provide 4 times as many liquor retailing outlets as exist today. And so I suggest it's unlikely that there will be many exceptions for trade areas coming forward, but there is that ability, and those rules have yet to be established. How do we contact landlords? Some have addresses and no phone numbers. You can email Kathy McDaniels if you're having a difficulty locating that information. We again first request you look at the data book, and if you still are unable to find what you need, contact Kathy McDaniels and she'll try and help. But quite honestly, we've asked for landlords to provide us this information, and you know, we're at their mercy if they fail to do that. Can I still bid if the landlord will not provide a letter of intent? Yes, absolutely. You're not required to do business at that location. You're not required to go into business at all. You're not obligated to do business with that landlord. I think there's distinct advantages to doing business at that location and with that landlord, and they've certainly been good business partners for the state for a number of years. And as you can see through the bid evaluation criteria, there's a financial impact that is taken into consideration should you choose not to stay in that location. But it is your decision, and you have options that allow you to request from the board an alternate location within a 1-mile radius. Keep in mind that if you do that, that new location is subject to local jurisdictional comment. And at a minimum, that means that there'll be a time delay because the board allows for 20 days for the public to comment on any new liquor location. In addition to that, of course, there is some degree of risk with respect to what that public comment would be. And this is not a risk if you're staying in the existing location, because the law specifically says that local jurisdictional challenge would not apply in the existing location, but it would should you elect to find an alternate location. But if you're having difficulty reaching agreement with the landlord, we encourage you to bid and find an alternate location. Would a computer screen print of an online banking statement showing amount of money in a bank account be okay to show proof of funds? No. What we've asked for is a letter, and we've been fairly specific on the website as to what that letter on the bank's letterhead must contain. And so we'll refer you back to the elements that are detailed on the website for the proof of funds letter. How long is the 17% licensing fee? There is no stated sunset clause. That is a licensing fee. It's a retail fee that applies to these transactions, and there's no stated period of time for which it is going to last. It's indefinite. Can you increase your proxy anytime during the bidding process? Yes, you may. When do you find out what the inventory value is? The inventory value is already stated on each auction page. What you'll see is the estimated inventory cost. Now that was based on our January data. Okay, the actual inventory cost to you will obviously vary based on actual inventory remaining, but that number, which is listed and included on each auction page, represents what your cost would be, taking into consideration the discounts we're providing, because you'd be buying this at our cost minus $7.97 a case. So you're getting quite a deal on that. But I would refer you back to the auction web pages so you can see what the estimated expense for that inventory would be. If the proxy value is not enough to secure the first bidder, would you give a chance if the highest bidder is willing to pay the expenses? No, your only opportunity is during the auction process. So we can't reopen the auction process or negotiate on the side. So you have to make a decision in advance if you want to use a proxy and what that proxy value is going to be. And you should keep in mind the effect of decisions you're making in terms of the inventory and fixtures. And you can see, again, for the stores that you're bidding on, what the expense is going to be for us to remove that inventory and those fixtures. So you do have the ability in advance to set a proxy value based on that. What is the current margin or markup on products in the store as it stands now? Presently, the board has a 51.9% markup on product. I have a question regarding bid deposits. For the $1,000 bid deposit, how is one store defined? Does this mean you're allowed to only submit bids for one store or only one high bid? If someone has a deposit in for $1,000 and they get outbid on the store, can they then move to the next store, or does that constitute multiple locations? So a $1,000 bid deposit actually allows you to bid on as many individual auctions as you want. There is no limit to the number of individual auctions that you're allowed to participate in with that $1,000 bid deposit. However, keep in mind, if you win that auction, or if you win multiple auctions, you have won those auctions, and you will be required to remit the full payment for those auctions. So you want to bid on what you can afford to win, and no more. Can a proxy bid be changed over the course of the auction? Yes, we've said that. So far, what you've seen in terms of disposition of landlords to lease, what have you seen in terms of disposition of landlords to lease the existing locations? We actually asked all of our landlords if they're willing to entertain new leases for liquor stores at these locations. We didn't have a 100% response rate. We had a very high percentage response rate, and everybody who did respond said that they are willing to entertain these new lease agreements. So a church group who thinks there are too many liquor stores in a trade area and wish to buy the right and retire it need not apply. I don't know if that's a question or not. Anyone participating in this auction has the same options. They can exercise their right, they can sell or transfer their right, or they can hold it for future action. Regarding the income on the annual report 2011, does this figure include the state taxes? Those are stated separately in the annual report. How is the bid affected if the landlord has indicated they have no interest in retaining the liquor store as a tenant or has already a pending lease with non-liquor operators after June 1st? So your bid will be affected in two ways. If you do not secure a letter of intent from a landlord, then you will not be able to assume responsibility for the leases, and I will incur a $3,000 expense to remove the leases. You still have the ability to buy the inventory, but you cannot buy it in place. So you could buy it off of my back dock, and there's an expense of $4.21 a case in order for me to pack that inventory up for you off my back dock. And if you do not buy the inventory at all, that expense is increased to $4.44, and that, along with the inventory fixture removal expense, is factored in evaluating your net bid value. Okay. Can you discuss the 17% gross liquor sales a retailer has to pay to the state? Are there any other taxes? I want to refer you back to our webpage. Now, this is actually our Liquor Board webpage, www.liq.wa.gov. Look for the transition page slide, the transition page. And on that transition page are price calculators. And the price calculators allow you to choose, this is essentially an Excel spreadsheet. It allows you to choose who you are. Are you a producer, a distributor, or a retailer? And who you're selling to. And based on that and the information you input, such as your cost and your markup, it will detail out the associated taxes and fees for that transaction. So I refer you to there. And if you have further questions, you can also contact the Department of Revenue, because they also have a FAQ document, and that may be of use to you. Will there be a breakdown of the individual bottles in inventory so we can see what we are buying and pricing, breaking down per SKU? Not until the actual inventory is finalized at the state store. So the 80% payment that will be due on May 11th will be based on 80% of the stated value on the auction page. So if your store auction says that it has an approximate cost base of $111,000, then you will be required to come up with an 80% payment towards that on May 11th. When we close the store on the 31st and conduct our final inventory, we will come up with the exact value, and the balance will then be due for that remaining inventory by June 15th. And of course, at that moment, you'll receive a full breakdown by product, by SKU of that inventory. Before you bid, do you have a chance to know the rental expense? No, but the overall income statements for each of the stores are posted, and you might be able to back into some numbers looking at square footage and the details that are posted within the data book. What time is the last bid accepted on the 20th? That's 4 o'clock. And again, I'll remind you that as long as there continues to be bidding activity on any given auction, that auction will not close. We'll leave it open for 5-minute increments until there's no longer any bidding activity. Question is, if I win the auction, can I still sell to restaurants at a 17% discount? Yes, we know we do not dictate, the state no longer will dictate pricing, whether it's to a consumer or to a licensee. Pricing is now a matter of the free market. Is the auction site tracking the net bid value? We need that amount to fully exercise our bids. Well, since your intent and ability documents are not due until the 20th, and you may submit them earlier, as I've already mentioned, but until we have all of those, and until the auction actually closes, we will not calculate net bid value, because we don't know what your intentions are, and we don't know how that affects the bidding value. Initial bid at proxy will be increased to assume that costs will be incurred for removing inventory, but if we then do not take the inventory, will initial costs be reduced? If you establish the intent and ability to take the inventory, you will be required to take the inventory. So it's really going to be based on what you opt to share with us on the 20th. The information in the data book is real information for each store. That was another question. Can the letter from a bank be applied to multiple stores? Again, if you win multiple stores, you will be required to pay for multiple stores. So you'll want to ensure your funding is adequate for what you secure. There is no recorded audio of this conference, so that is not going to be available. If I buy the inventory in place and remove it by myself, then, is there zero devaluation? If you buy the inventory in place, then there is no devaluation of your bid. So this is an important distinction that is something you may consider. You can establish a short-term lease with a landlord that gives you property rights and thus allows you to assume responsibility for the fixtures and the inventory without having any bid devaluation impact. There is no requirement from our perspective on the duration of that property access, those property rights. I simply need to pass my property rights on to somebody else. I need to know that when I leave the store and I leave that inventory and those fixtures in place, that you have, with the blessing of the landlord, assumed those rights and responsibilities. It doesn't matter to me if you did that for a day, a week, a month, or a year, or 10 years. You don't have to demonstrate that your property access through your letter of intent is for any duration beyond just the time it takes for you to go in and assume those responsibilities. Okay, to clarify, if one has the highest bid, he or she will not win if their intent and ability docs have not been submitted by 420. No, that's not necessarily true. You do not have to submit intent and ability documentation. It is completely optional. It may not even be necessary. It depends on what the other bidders are doing. So, for instance, if you're competing on a particular auction for a store and nobody has the intention of occupying that space or buying the inventory, then nobody needs to submit evidence of intent or ability, and in fact, the bid is going to be awarded simply based on the high bid amount. So it is possible to be the highest bidder, to not buy the inventory, and to not assume responsibility for the fixtures. In other words, not having a letter of intent, and you could still win. It really depends on what your competition is planning to do. Okay, question. Why is it that if an on-premise licensee purchases directly from a supplier, only the new 10% distributor fee is charged? However, if an on-premise licensee purchases from an off-premise licensee, the 10% distributor fee is paid in addition to the new 17% fee. Now, I'm going to defer that question. If you want to discuss that with me separately, I will. We cover this in the board rules, and those are posted. Also, there's a link on our website that explains how these fees and when these fees apply. Okay. If a bidder is successful by exercising their proxy for inventory devaluation, would they be reimbursed for the additional proxy amount if they then bought the inventory? Okay, well, keep in mind, you're not, it's kind of a confusing question, but we're only going to exercise your proxy to the extent necessary to win the bid. And you will be required to pay that amount in full on May 7th. If you also had intended to purchase the inventory, that's a separate transaction. Okay, so, and that payment is due 80% on the 11th and the balance of 20% on the 15th. It's a separate transaction. The landlord's bidding on the right as well. They won't give us a letter of intent, and driving the value down. What is my option? Again, you have options of seeking alternate locations or trying to convince the landlord to reconsider. Let's say I'm in Tacoma and interested in 3 area stores, but I want to own just one. Is there a way I could make a bid and apply it to any of those 3 stores, saying I just want one of them? No. If you bid on a store and you win, then congratulations, you own the right to that store. So do not bid on something that you cannot actually afford, because then you're putting your bid deposit at risk, and you're putting your other auctions at risk as well. This is a contract, and it's one of the things we made clear at the very beginning within our terms and conditions. By participating in this bidding exercise, you are effectively entering into a contract. So what about if someone purchases all the liquor rights? Anybody who is participating in this auction, whether you're an individual or a collection of individuals or an entity, a corporation, everybody has the same options. And that is, you can exercise those rights, you can sell or transfer those rights, or you can hold on to those rights. So everybody has the same opportunity. If you do not stay in the location, but you do buy the inventory, when does the inventory have to be picked up? We actually would ask that you pick that up in the first couple of weeks in June. There's some flexibility there. There isn't flexibility on the payment of the inventory, but we could work on the scheduling of picking it up. It would not be required to be picked up prior to June 1st, and we could work with you individually on the timing. There is some flexibility there. If the winning bidder decides that they do not want the location, will the next highest bidder be awarded the location? Again, if you are after the evaluation period the winner, then you have the option of exercising it, selling it, or holding on to it. But you do not have the option to not pay for it. You will have to pay for what you've just won, and then exercise your options beyond that. An individual store bidder could be the high bidder, but still not win if the state goes with the sale of all stores to the all-inclusive bidder. Well, again, we are going to compare the option of the individual store bids, taking into consideration the demonstrated intent and ability, and that will be compared to the value of any all-store bids along with their demonstrated intent and ability. So keep in mind that if we had an all-store bidder, and well, we do, we've got, I think, 11 all-store bidders. Those all-store bidders have the option to share with us for evaluation purposes, demonstrate their intent and ability to occupy 169 locations, and proof of funds equivalent to the value of the inventory at all those 169 locations. If they elect not to do that, then we must consider that in evaluating what the real net value of their bid is. So there's no difference in terms of how we compare an all-store network bid versus an individual store bid. We still look at the demonstrated intent and ability. So I want to go back again. There's requesting a clarification on the example that I gave. In fact, I'm going to put that slide back up for us to look at. So in this example, the question says, if bidder A has the highest bid and the highest proxy bid, which again in this case they do, but loses out because they do not want to purchase the inventory or lease that space, will they be given the opportunity to pay the difference of his overall net bid value compared to bidder D? It's not, I would say it's not an opportunity, it's what would happen. So because in this case, bidder A voluntarily stated that they were willing to pay up to $20,000 in order to secure the bid. In other words, bidder A said, I do not want to lose this auction for less than $20,000. So, in this example, we would automatically require bidder A to pay $14,980, which is the difference between their net bid value and the most favorable net bid value, plus $100, added to their offer of $8,000. We would not exercise their proxy any more than was necessary to win the auction, which is essentially what their proxy stated to begin with. You know, I don't have the annual report here in front of me. I apologize. I would ask if you've got questions about the annual report, why don't you contact us separately and we will address your specific questions. Please clarify the taxes and fees per bottle of spirits. Again, go to the website, look at the transition page under price calculators. It's all broken out, It's all broken out based on whether you're a producer, distributor, or retailer, and who you're selling to. You input your assumptions of cost and markup. It will tell you what fees and taxes apply. Will there be limits on how many retail licenses are available? By law, there is no limit to the number of retail licenses associated with premises that are at least 10,000 square feet. Beyond that, the only provision for additional smaller retail locations would fall within the trade area definition that the board defines. And as I've already suggested, we anticipate a very conservative approach when it comes to those additional locations. No priority, so will I be getting a priority to fill available spots if there are any in my trade area? That whole trade area process, again, has not yet been defined. I'm trying to ask if will you adjust my proxy bid to account for inventory costs and removing fixtures? I may then be able to work out a lease so you will not incur that expense. Will you then reduce my bid amount due because you did not, in fact, incur that expense? Just to restate it, and I remind you of this timeline that we have. We've got to get out of the way so that you guys can get in business, right? So we also have to generate maximum reasonable value. And if we are going to incur expense based on decisions that others make, or be it landlords or be it bidders, we have to consider that in this transition process. So all I can do is base my evaluation on what you reasonably demonstrate to me. If you provide proof of funding and a letter of intent, I will take that into consideration, and I'll assume that you're going to buy the inventory in place, and I'm not going to have to remove it, and I'm not going to have to remove the fixtures. But if you don't, then I have to assume I am going to incur that expense, and that will factor in to the award process. Can you move the license to existing retail stores? So if you win this right, and again, you have the ability to request an alternate location within 1 radius mile of the existing location. Kathy McDaniel's email address is K as in King, H as in Henry, M as in Mary, at liq.wa.gov. Again, the requirements for proof of funds are specific. All elements, as stated on the website, are required in order for that proof of funds to be valid. I suggest that you review it carefully. It's a short list of requirements. I think they're rather basic requirements, but all elements must be present in order for us to consider that proof of funds as well as the letter of intent. So review it carefully before you submit it. If the intent and ability docs have not been submitted by 4/20, yet the bidder intends to purchase the inventory fixture license, can that bidder's winning bid be awarded to someone else who did submit their docs? If that may happen during the evaluation process, we're going to use this evaluation example on your screen now. You know, you could assume that bidder A did not submit any documentation. Or you could assume that bidder B provided only proof of funds, but no letter of intent. Whereas we would assume that bidder C provided a letter of intent, but no proof of funds, and bidder D provided both a letter of intent and proof of funds. So based on how that plays out, the winning bidder will be determined. We are requesting that your proof of funds are validated by an established financial institution. So you need to consider options of how you can involve them in that process. Will the inventory value go down? It may. It also may go up. I think what you can count on is the inventory value will be different than what we've stated it to be, at least on the basis of the transactions that are going to be taking place between now and the end of May. In the future, the bidder can add another business such as soft drinks or liquor. Yes, there's no requirements or restrictions on what type of business can be conducted at these locations that are selling liquor, as long as you're properly licensed to do so. How soon can you get your bid deposits back? You know, as soon as all the auctions have been fully awarded, we'll begin processing those refunds. So it will happen very, very soon after, you know, I would imagine during the first 2 weeks of May. When do you think the distributors will tell us what the cost of liquor is? My understanding is that they are publishing price lists now, so that information should be increasingly available. Will the 51.9% markup stay in place? Again, all pricing is subject to really the free market, so your markups are your decisions. The retail fees and taxes are mandated and outlined in the price calculators on our website. What happens if there is a bidder for all stores that truly plans on not buying not buying and being a spoiler? The only amount he'll be out is $5,000 credit card deposit. Is that correct? Well, no. They will, if they're awarded the right, which is right now valued at, as I said, about $600,000, they're going to be out $600,000, regardless of what they decide to do with that right. Will the state start the auction process over, or how will a bidder for an individual store that has no intent to purchase? He will only be out the $1,000 bid deposit. Will the state back up the auction to the first legitimate bidder by negating the non-paying winner's bids? Okay, so if we do have someone who fails to perform, the state will take appropriate action. Clearly, they'll lose their bid deposit, and there are additional remedies afforded by law that will be pursued. So there'll be consequences clearly to those individuals. And then, yes, we would go to the next in line based, again, on net bid value as calculated and shared with you on the screen there. Would landlords be giving out more than one letter of intent to the same property? Yes, that's already happened. That's an individual landlord decision, but there's nothing that would prevent that except their own decision. Do you compete with a landlord who's indicated their intent to bid on the auction themselves? That's up to you to determine that. Can't really give you advice, but we've outlined several options that you do have. Is there a chance that the LCB will operate the store past May 31st? What if you can't be ready by June 1st? So we're not allowed to operate past May 31st. That must be our last day of retail sales. We do not have to vacate on June 1st, but I want to be prepared to in the event you want to be there. It does not affect the bid evaluation process if you're not taking access to that location, or if you're not going to be at least actively selling on June 1st. That doesn't affect the bid evaluation process. As long as you can establish property access to that location so that I can get out. I just want to be out of your way. If I bid on two stores, A and B, and I'm the apparent winner of B, not just A, but let her find out I won A as well due to a price adjustment, am I responsible for both stores, or can I just be responsible for B? Again, I just want to caution you to not participate in more than you can actually handle. We understand that there are some unique aspects to this bid process, and we'll be reasonable as we work through some of those details should that happen. What will the turnaround time be if the lawsuit is successful? You know, whatever, I'm not even sure what the turnaround time is meant to reflect, but we will, as swiftly as we have been mandated to respond in this situation, if we're directed otherwise, we will be equally swift to implement that new direction. And might I add, we might be even more inspired. But certainly we'll be swift. What about the expired inventory? You know, I'm not sure what I don't know what you mean by expired inventory. So if you could clarify that question, I'll try and answer it. Will the stores carry the state of Washington name, or will they be renamed by the new owner? They will not carry the state of Washington's name. It will be up to the new owner to determine what the name will be, but it must not be a state of Washington name. If the winning bidder fails to provide funds for the action, will it be awarded the next highest bidder? I think I've covered that. The ending time of the auction and with respect to proxy bidding, Again, as long as there is bidding activity, the auction will not close. Bidding activity within a 5-minute period. This proxy bidding happens immediately. It doesn't take any time. If you have 2 proxy bids, they will exercise against each other without delay. So, and as long as that's taking place until one of those proxies is fully exercised and there's only one remaining, the bid will remain open. Will the purchase price of the existing inventory be at the state's true cost or at the retail with the 51% markup? No, there is absolutely no markup in the purchase price of the existing inventory. You're buying it at my landed cost. So what I paid the supplier to deliver it to the distribution center, there may be a small freight charge getting it to the store. To be honest with you, I'd have to confirm that. But this is cost, and it's actually below cost because I'm then going to discount it $7.97 a case below my cost, because that's reflective of expense I'm going to incur in the reverse logistics. So you're truly getting this inventory below cost. There is no 51% markup included. At the beginning of the presentation, I mentioned that bids need to be entered by the 19th. Can final proxy be entered by the 19th or 20th at 4? So let me make that clear. You have until the 19th to submit a bid deposit. Now, many of you already have done that. If you're bidding right now, it's because you have a bid deposit on file, so you don't need to be worried about that. But if you or somebody has not yet submitted a bid deposit, you have not yet participated in the bid process, you have until the 19th to submit your bid deposit. If you don't, and you decide that on the 20th you want to participate in the auction, you won't be able to. So you have to make sure your bid deposit is on file by the 19th in order to participate in the auction. So if you're already participating, you don't need to worry about it. Final proxies can be adjusted up until the end of the auction, really. I mean, before the auction closes, as long as there's auction activity, you know, so theoretically at 3:59 on the 20th, you could go in and adjust your proxy. If there's activity and the bidding has continued, it's now 4:30 or it's 5 o'clock, whatever it is, you can still adjust your proxy. As long as the auction is open, you have the ability to adjust your proxy. Regarding current employees, what is their understanding of this process, the hire and fire situation? Again, I guess I don't understand the question. Our employees have been notified that they're being laid off effective June 15th, at least our store employees, and June 30th for some of our headquarters staff. All of them are available, and I would highly encourage your consideration in bringing what are proven to be very capable, knowledgeable employees. And as we shared at the Bidders Conference, there is a post-auction incentive program that can allow you to earn a substantial amount of your bid value back through hiring those employees. As the balance of the inventory payment is due on 6/15, does that mean the state expects to vacate existing stores on that date? What is the timetable? We're prepared to be out of the stores by June 1st. Now, if you're not occupying that space, then you know I'm not. I don't have to be out by June 1st, and I have a little additional time. But I do know that many of these locations will want us out of the way, so we're prepared to be out of the way. If you're going to be buying the inventory off my back dock, that'll be available soon after we close on May 31st. We'll have resources on site doing our final inventories and packing that inventory up as necessary. And so it'll be available that following week, as early as that following week, if you wanted to pick it up. Or if you were going to be occupying that space, we can get out of the way as early as the 1st. So it's based on what you tell us. And your letter of intent communicates that to us and allows us to plan accordingly. Can you sublease the right? Yes. If you win this right, you can lease it to somebody else. If they exercise the right, in other words, if they apply for a liquor license, you will still be the owner of record of that right and would also have to be a party to that liquor license, but you may lease that right. What price level is the inventory based on? It's our cost. So the inventory is based on my cost. Your list includes 167 stores. Which 2 are missing? There's 169? Uh, 168? You guys aren't helping me here. Oh, I'm sorry. There's 167 listed auctions, and plus the. So if I said 169 earlier, my mistake. Can you repeat the calculator that shows taxes on the sale again? The location for that calculator is on our website. So you go to www.liq.wa.gov and look for the transition page on that website. And under the transition page will be price calculators. Locations. What about the locations such as Joint Base Lewis and McChord? We have other military locations. Those will continue as federally operated retail locations. What does the TTL, direct expense and indirect expense, mean on your financials? TTL means total. Total this year or total last year. So TTL, if you see that abbreviation on our financial documents, TTL is total this year. TLL would be total last year. Good question. Is there a distance that the new licensed store must be from the existing location? Yes, 1 radius mile. Does the inventory include a lot of dead stock that has no market in the past? No, I would say it does not include a lot of dead stock. In fact, we turn our inventory on average nearly 12 times a year. We've also, and we only list items that sell. So there's, there's always some special order items that we've tried, new market products in the sort, and there's going to be a mix of that in the inventory. But our total turns are nearly 12, which means we clear the shelves every month. And I'm going to take advantage of that comment too to emphasize. I think this is where one of the real opportunities lie for those of you considering running these stores, is that we offer 1,400 items on average in our state stores now. We turn them 12 times a year. We're clearing the shelves and restocking regularly. We've got millions of customers coming in to buy those products. The big box stores are going to carry about 300 items. So, and they're going to be the top 300 items that you'll be carrying as well. But this is where I think you have the opportunity to serve what's been an established marketplace for the other 1,100 items. Cost per case again. The cost per case with respect to, you're going to be buying it, and it's really the dollar value that is listed on the web page itself reflects what the cost for that inventory is going to be, and it is our cost minus $7.97 a case, reflecting a the fact that I'll be avoiding some reverse logistics expense. How would I know what is the inventory, and what if my proof of funds are less than the actual inventory cost? Your proof of funds needs to be at least equivalent to the stated approximate inventory value on the auction for which you're participating. Otherwise, it can't be considered. Can you give us the names of the distributors? They're all listed on our website. Anyone who's applied for a distributor license, that information is posted on our website. So I'll refer you there. I have $300,000 to purchase liquor rights. It's tied up in the stock market. I can sell and transfer that money. How is that calculated in a proof of funds letter? Does my proof of funds have to be liquid money in my bank, or can the proof of funds include my personal value? At present, what we've stated is essentially they have to be liquid funds. Is the relocation of the store rights an interpretation of 1183 made by the WSLCB subject to litigation after the auction? So the relocation within 1 radius mile is a board rule that was made. Anything is subject to litigation. So the basis of that rule was a realization that we did not believe we could obligate bidders to do business with landlords any more than we could obligate landlords to do business with bidders. And as you both communities have shared, that is the case. We're finding that landlords in some cases may not want to do business with bidders, and in some cases bidders may not want to do business with landlords. So we've found it reasonable to provide an alternative. What is stated in 1183 is that these rights must be freely alienable, which suggests that they are relocatable. So there was sound basis for this board rule, but anything is subject to litigation. If there is litigation that ultimately names the state as plaintiff for mishandling the auction, will funds be returned to the successful buyer? Well, you know, we're getting into a foray that I'm not a lawyer, so I really have to limit my perspective here. But being named in a litigation is different than being found to have violated a law and being ultimately named responsible for negligence of some sort. So I would suggest that since nothing prevents litigation and nothing prevents naming people in litigation, that would not be a basis for changing direction of an auction or certainly returning funds. I would think that any outcome of litigation would dictate and direct what would have to happen to those impacted by such litigation. I have to leave it at that, I suppose. In reference to turnaround time, what is turnaround time to getting our $1,000 or $5,000 back? This is the bid deposits. You know, those would be processed as soon as the auction awards have been completed. The directive would be given to immediately begin processing those refunds. Refunds, I think it can depend on the nature of how your refund was given. Whether you brought cash, check, or a credit card could affect the actual turnaround time based on the processing of the other financial institutions that may be involved in that. But the actual processing would begin immediately after the end of the award process. If a bottle of liquor has an expired date and it passed that date, that is expired inventory. Oh, okay, so yeah, so thank you for that clarification. I think the earlier question is, do we have any expired inventory? Let me Let me find that question to make sure here. And the answer, we have dealt with, we deal with expired inventory. Not much of our product falls into that category. You know, eggnog comes to mind, that obviously does, but that inventory would not be passed on. We have a process already in place that would weed that out. Okay. What about an Indian reservation? You know, the tribal stores that exist, and there's a little over a dozen of them across the state. They have the ability to continue to operate as a contract store. They have to essentially apply for a liquor or spirit retail license in order to do so, and we anticipate they will. With respect to buying the inventory, you're able to buy the inventory that is in the store. We do not have a process that will allow you to buy more inventory than is actually in that location. Having said that, this question was raised recently with, you know, what if you wanted to, if we didn't have a buyer for the inventory at another location and we were otherwise going to have to truck it back to the DC, could you buy that? I suppose that is a possibility. We haven't figured out all the logistics of how that would happen, but I suppose that's a possibility that you could buy additional inventory out of another store if that bidder didn't want it, you know, and you want to come in and buy it off our back dock. So there's that possibility. We really won't know if that exists though until all the award process is determined. Another question I almost missed: when can we talk to present employees about possible employment? Can they be interviewed now? Yes, they can. I would encourage that you do that. Again, we do have some tremendous talented employees, both with retail, distribution, and administrative skills in terms of running this business. So you are welcome to approach them now. And we're also working with our HR department to see if there's a register or something we can provide to you as well to make it easy to know who is available and interested. But please, by all means, engage these employees and consider them in your business model. It makes a lot of sense. Is there, there's a question about where store 43. Store 43 was relocated a block and around the corner, and was reestablished as store 143. So store 43 in West Seattle no longer exists. It was replaced by store 143. Existing inventory has one less than case. Has one less than case. How the 797? I don't understand that. Do you understand that? Oh, okay. Yeah. So if you have the per case cost applies to even a half a case. So a partial case will still be benefited of this discount, because the case is how much it costs me to move a box, regardless of its weight or content. What is my take on BevMo's and Total Wines of the world? I've read a lot recently that they when they come to town, they offer prices at or below cost to try and get rid of competition. Once a good percentage of the small businesses have gone out of business, they will hike the prices back up. Well, BevMo and Total Wine have indicated an interest. I think perhaps many of us have seen articles suggesting that. And you can look at our website to find out if they've actually applied for liquor licenses. I think they may have already. Nobody is allowed to sell below cost. Now, we have an interesting exception available to us in this transition period, but in terms of normal retail, nobody will be allowed to sell below cost. But that, this is going to be an open market, and so there will be various business models to consider and to compete against. Can you distribute to restaurants? So as an operator of these stores, you will be allowed to sell to restaurants. If you distribute, you will need a distributor's license, and you will have to be responsible for the various fees associated with that. But you can sell to restaurants, but you do have a limitation in terms of the volume that you're allowed to sell to restaurants, and that volume is limited to 24 liters per sale per day. How close can additional stores be open from an existing store? Again, right now, there is no limit on additional large retail stores. So if there is not a 10,000 square foot facility selling liquor on June 1st, nothing prevents it from happening in July. There's no limit on the large retail locations participating. And there's no restriction on their proximity to other businesses either. Can we also contact district managers as well? We would like to hire existing employees, same rates and benefits to hire from all existing. You can contact any employee that you'd be interested in, and as I said, we have a variety of skill sets ranging from distribution center to retail to administrative and management staff. We have IT professionals. Because we have over 1,000 people being impacted. Because we're downsizing as an agency, it's not just our business enterprise that's affected, it's our entire agency. So we have reduced or are reducing the staff in our IT department, in our finance department, in our human resource group, in our contracts office, our purchasing group, our distribution, our retail, our general management. So we have skill sets available in a variety of capacities, and we'd be happy to have you entertain those skill sets, and I think you'd be smart to do so. There is not, a question is, are there lease amounts available for all the stores? No, that's not available at the present. At least for the purpose of this auction. You can always request this information through a public information request, but the reality is you're not likely to get it in time. So effectively, no, it's not available. If a contract store later comes up for sale and we want to purchase, will that location be exempt from the 10,000 square foot rule? Yes. Contract stores have a similar benefit of being able to operate under 10,000 square feet. Nothing prevents you from buying those rights in addition to those you might win here in this environment. If you were to purchase one of those stores, would you be able to sell to the licensees, the bars or restaurants, over the 24 liters per transaction per day? And yes, you would. That is a benefit of the contract stores. It's unique to the contract stores. So you would then be able to sell in volume if you had a contract store right. It would be best to provide us all with a list, and we were willing to hire as many people as possible. Yeah, I'm going to work with, anticipate a notice. We'll probably send it out via email of how you can access information about our available employees. But you certainly can go to them directly if you have a particular store in mind. Can any store greater than 10,000 square foot sell liquor nearby? Yes, as long as they're licensed to do so. Will the winning bidders be able to purchase the existing point of sale systems that the state currently has in place? This is an area that we're currently evaluating right now. We have fairly sophisticated point of sale systems in place in all the stores, and we're evaluating what we're going to do with them, whether we're going to leave them as a fixture or remove them and auction them off separately. And we anticipate a decision on that very shortly. What is a contract store? A contract store is it's currently a liquor store that's operated by a private individual under contract with the state. So on behalf of the state, typically they're in rural areas of the state, and they operate those liquor stores on our behalf because it's traditionally been more financially viable for that to happen. You mentioned something about being able to sell to restaurants. Can you clarify? It is limited to 3 liters per day. Any other exceptions to sell more? So yes, there is a specific element within the law that says that spirit retailers are limited to sell 24 liters per transaction or per sale per day. It's in section 103, item 1, within the language of Initiative 1183. So if you look at section 103, item 1, it specifically states that spirit retailers are limited to 24 liters per sale. The board has clarified through rule that that is 24 liters per sale per day. But you may sell to restaurants just within those limits. Contract stores do not have that limit. The point of sale equipment in the stores now, it's kind of a best of kind of compilation. We have IBM hardware along with HP hardware and Verifone equipment, and it's a solution that has been assembled to meet the needs of our business. And if we're going to make that available to you, we'll provide you the specific, more specific information. But you may not sell in volume to licensees. You're limited to 24 liters per sale per day. If the POS system is not part of the current list of fixtures, please clarify what is being considered as a fixture besides the POS system. That is listed in the terms and conditions, but just roughly speaking, it's the fixtures that we're intending to leave are all the existing shelving, which are installed, the cash register furniture, right? So the actual, if not the point of sale equipment, the fixtures that the point of sale equipment sit upon would remain. Any of the floor display fixtures, going to the back office, the desks, the chairs, the safe, those would remain. And those are detailed out on the terms and conditions. And we'll provide additional information and clarification with respect to the POS probably next week, early next week before the auction closes. But at the moment, the POS is not included. Is it correct that most of the licensee sales today are for 20 cases a week? If so, we would lose a great portion of the business due to the limitation. I'll tell you that our licensee business is about 30% of our total sales. And so you do need to factor in that a significant portion of those sales would not be serviceable from your location. You could serve every day, up to 24 liters, but that may fall short of the volume requirements of some licensees, or some licensees may not want to shop every day. So you definitely need to factor that in your business plan. The POS software is licensed software, so it would not be, if we did include the POS equipment, it would not include software to run on the equipment. That's a licensed product that we do not own. To clarify, the stores that we are auctioning off are not contract stores. We are auctioning off state liquor stores, and those state liquor stores, like the big box retailers or any other retailer of spirits, have a limitation on volume sales to licensees. The only entity that is not limited in terms of the volume of sales to licensees are contract stores, but we are not auctioning off those contract stores. Those contract stores are already operated by individuals who have the ability to apply for a spirit retail license and continue an operation. They do have the ability to sell or transfer that, and in that regard, you have the ability to also acquire those contract stores, but the state is not brokering that deal. That would be something for you to individually pursue if that was your interest. Beverage coolers are those included in the fixtures. It appears that the beverage coolers are included in the remaining fixtures. The POS rental fees are not in the data book. We don't rent those point of sale equipment. We effectively own those. Is it possible to open a drive-through location? No, it is not. That is not permitted by law. Can you deliver to on-premise licensees? Yes, you can. Would we be able to deliver to a restaurant? Yes, so we just said that. Okay. I do not want to stay in the location, but I want to get the fixtures. Can I get them from you later after they've been removed? I know I will still be charged for the removal fee. Okay, so if we remove the fixtures, if we have to assume that responsibility, we have a couple of options of how we'll pursue that. It may involve us physically removing them. It may involve us selling them to somebody else to do that. It will really depend. If we end up removing them, we will have to, some of them will be resellable, such as the coolers. And if we end up with additional coolers that we've had to remove, we will auction those off under a separate process. I would just encourage you, if you're not going to stay in that location, but you want the fixtures, try to establish even a short-term lease so that you can get those fixtures and not be financially penalized in terms of the evaluation process of us removing them. As a clarification, suppliers and distributors can sell to those restaurants and bars and have no limitation on sales per day. No, suppliers, suppliers and distributors can, you're right, suppliers and distributors can sell if they're properly licensed to do so, and without limitation. So that's true. Are cameras included? Yes, the existing cameras and DVR systems that are installed will be included. However, there will be no hard drive in the DVR. We'll be retaining those hard drives for our own business purposes, but the equipment will remain in the location. What if a restaurant that purchases from an existing location only orders one time a week? Will we be able to sell to them daily allowable amounts times 7 days? Yes, you can sell up to 24 liters per sale per day. So don't have any questions that I haven't answered. I've been requested to repeat the last one, so I'll do that. But if you do have questions, I encourage you, or if I missed your question by chance as I've been scrolling through these, I'm trying not to repeat unnecessarily. So if I haven't answered your question, or if it still is unclear, please feel free to answer again. But to repeat what I just said, if a restaurant that purchases from an existing location only orders one time per week, would you be able to sell to them daily allowable amounts times 7 days? You could sell to a licensee or a restaurant 24 liters per sale per day.
And they're trying to lump it into one.
No, you can sell 24 liters per sale per day. That's what you can do. No, I've clarified, I think, on the POS, at present, the point of sale system is not included as a fixture. We are evaluating that. If we come to a different determination, we'll let you know. What is inventory contract offered? What does that mean? Well, if you provide proof of funds, that is your indication to us that you're going to be buying the inventory. And of course, if you accompany that with a letter of intent, that tells us you're going to be buying the inventory in place. Otherwise, you'll be buying it off of our back dock. So we will draft a simple agreement for you for that transaction, because this is a separate transaction, and it will basically outline the elements that we've talked about, that you'll be required to come in either how you'll take possession of that inventory, whether it's on our back dock or in our in place, and the payment terms that we've shared. So it's basically a document to transact that, because that's separate from this auction process. What is the incentive to rehire employees? So what we shared at last week's bidder conference is, while many of you have indicated an interest and even an intent to hire employees, we recognize that we can't use that as a basis for awarding this contract. We have to do that. We have to kind of keep this separate. I think that's both so this is fair and unbiased, and not to be self-serving, but also just because someone has the intent, if they don't follow through on it, then that may not be fair, right? So what we decided, though, is that we too hope that our employees will find some new homes in this business, and that if they don't, the state is facing a substantial unemployment expense to the tune of $8 million a year. So what we shared at last week's bidders conference, and the details are posted on the website, is that if indeed you elect to hire any LCB displaced employees, that for the period in which they're hired between June of 2012 and March of 2013, which is a 10-month period, you essentially earn credits, if you will, of employee months, and you can apply for a rebate of your 6% buyer's premium. And the example we used last week was, if you won an auction for $8,000, you pay a $480 buyer's premium. That's the 6%. If you hired the employees associated with that store, which on average are 4 employees, and you hired them for that entire duration, that 10-month period beginning June 1 through March of 2013, then you could get 100% of your buyer's premium back. Of course, that's only $480 and may not be as much of an incentive as is possible. And so we've added a factor of 10 to that. And so what that means is, if you did hire those employees for that 10-month period of time, you could actually qualify for a rebate totaling $4,800, more than half of what you paid to acquire the right to begin with. And so that's a bidder, that's an incentive, a post-auction incentive that is available. It's calculated based on the number of employees you elect to hire that were displaced from the LCD and the period of time during that 10-month period that you hired them. How is the lottery income posted in the data book? Yeah, gross sales are included in the, lottery sales are included in that. But in our annual report, you can see liquor sales versus non-liquor sales. And, we did a pretty good job selling lottery, but it really does not sway the gross sales of liquor. I mean, that was clearly the dominating product that we sold. For Class H sales or licensee sales, clarify that's per sale, per day, per licensee. In other words, you can't break up the sales into different orders. And yes, that's correct. When you're selling to a licensee, you can have one transaction a day, and that transaction can only be a maximum of 24 liters. If you're the winner and you have the right to sell liquor, do I have a time period that I have to start selling liquor? No. If you win this right, you own it exclusively, you own it for life or until you sell or transfer it to somebody else. That right can be exercised. In other words, you can go into business and start selling liquor, or you can hold it for future action. There is no time limit for which you have to begin exercising that right. Now, there may be time limits, or there will be time limits if you say, I want to buy the inventory, or I want to occupy that space. There'll be expectations around that. But other than that, there is no expectation or mandate as to when you have to go into business, because the law specifically says you don't have to go into business ever, should you choose. Clarification on the gross sales. The gross sales listed in the data book do not include lottery. So it is just spirits, beer, and wine. So I misspoke. Again, gross sales as listed in the data book are just spirits, beer, and wine, do not include lottery. Can you get data of the premise sales?
On Highland 83, Highland 83 transition list, it's there, for sure.
So,
Sales by state store. He's looking for the
bear with us 1 second.
You go to Highland 83.
Hold on. So bear with. Okay, so just I had to clarify with my team here. So if you're looking for sales of on-premise versus off-premise, consumers versus, say, licensees, that information is on our transition page, and it breaks it out by location and by on-premise and off-premise sales. So yes, that information is there. And if you want to sell to 5 different restaurants a day, would it be 5 times 24 liters for that day? Yes, a restaurant, so if we use a chain, let's say there's a chain of restaurants in Azteca, for instance. You could sell, each Azteca restaurant has its own liquor license. So you could have all 5 of those restaurants serviced on the same day for up to 24 liters. The gross sales in the data book does not include taxes. It's just sales. If you sell to restaurants or to a bar, will the 17% charge be on the sticker price or the discounted price that you actually charge them? Well, the reality is this is a fee. The 17% is a fee that you as a retailer will be required to remit to the state. How you recover that fee in your pricing model is entirely up to you. Whether you display that in your price, well, presently, if you go into our liquor stores and you see Cuervo is being sold for $19.95, that includes all taxes and fees. That's your out-the-door price. You're not required to display pricing that way. You may elect to do it. You may elect to break it out separately. But as a retailer, you will be required to remit a 17% fee along with other relevant taxes to the state. It's up to you. You're going to charge your customers based on your own individual business model and decisions. Can you get a breakdown of sales by SKU per month? No, that's not information that's available for the purpose of this auction. Is the lottery license included with the liquor license? No, it is not. And I don't know that there is a license. Maybe there is. I'm not even sure if a license is necessary, but you'll have to establish your own relationship with the lottery. I will say that the lottery would love to work with you. They're easy to work with, and they certainly have been helpful to us. So the 17% will have to be collected from licensees as well. Again, I'm going to defer you back to the website. Look at the price calculator. It clearly articulates, based on who you are and who you're selling to, what fees and taxes apply to which transaction. So I'm going to defer you there. The retail stores larger than 10,000 square feet have to abide by on-premise licensee limitations of 24 liters per day. Yes, there is only one exception to the volume sales restriction, and that is a contract liquor store, or, as pointed out earlier, suppliers and distributors themselves. But in terms of retailers, the only retailer, I'll just say it again, the only retailer allowed to sell in volume to a licensee is what will be a former contract liquor store. They are the only retailer allowed to sell in volume. Everyone else, every other retailer, is limited to 24 liters per sale per day. Okay. Yeah, there's a distributor list. Again, you go on our website. You can see pending and issued license applications by retailer, by location. All that information is there. So, I think part of the challenge is we have really sought to provide volumes and volumes of information at your request. That ends up, and we try to keep it as organized as possible. I appreciate it can be a bit daunting to sort through it all, but it is there. Let's see, does that include Costco, referring back to the retailers? As long as Costco is serving as a retailer, and if they apply for a distributor license, then they would not be restricted in terms of volume sales. If Costco chooses to be a retailer, then they are subject to the same limitations of 24 liters per sale per day. I assume that restaurant owners are aware that they will be required to present proof of license to the new store owners. Yeah, they do it. They do it for us, and so I think they're accustomed to doing that. Is it possible to get a tobacco license at a current location? It's possible to get all kinds of licenses at the current location. You could sell fishing licenses if you're licensed to do so, right? There is no stated restriction from a board's perspective on what could be sold along with these liquor products. You'll just have to pursue the appropriate licensing from those authorities. Why can't you get SKUs sold per month for a store even though they're through public records? Oh, let me be clear. You can get this information. you can get all this information. That anything I've said isn't available. What I've tried to be clear is it's not available in time. In all practical purposes, it's not likely to be made available before this auction closes. You can request, if you want this information, submit a public records request. If it's available, then it will be provided. And if it's available immediately, it'll be provided immediately. But I'm just not suggesting that if you make a request, you're going to get it before the auction closes. So, but you might. So ask for it. And it's been suggested that you've asked via public records and you've been told no. I think it may not be. I would ask again or seek clarification, because it is information that can ultimately be assembled, and we're required to provide this type of information. But if it's not already in a canned report, it's going to take time, and I'm pretty busy running an auction right now, so that's why I suggest you're probably not going to get it in time. Let's see. The landlord does have the ability to restrict what can be sold. This is true. So, I mean, again, the board does not place restrictions on commingling other products to be sold next to the liquor, but landlords might. Or other licensing authorities outside of liquor might, but we don't. Oh, are we over time? Oh my gosh, you guys, we've been having so much fun. We're 7 minutes over. So I'm gonna allow for 3 more questions to get submitted, but then we're gonna have to bring a close to this. And you can continue. I think Kathy's done an amazing job responding to volumes of phone calls and emails, and she'll continue to do that. We'll do our best to provide this information to you guys. Let's see, if you have information that you want to request, you contact our public records office at liq.wa.gov and simply state the information that you're asking for, and we'll try and provide that. So if there's a little store next to you selling wine and beer, is it possible for me to get a license for wines and beer at a liquor store? It is possible. Yes, it is possible. Okay, a lot of kudos. We appreciate it. The team is working really hard. You know, I know this is a weird thing we're going through. I'm glad that we're getting the level of participation that we are. I'm glad you guys are seeing value in this business opportunity. I think I think there are some real prospects there. We're not planning another conference, to be honest with you. You know, if we are going to have one, we'll notify you. But we're not planning to offer another conference. So you can certainly let us know if you have questions, and we'll try and answer them. So, all right. I think we're going to put a wrap on this. Good luck to all of you. Please get your proof of funds and letters of intent into us if you want us to consider those. Make sure you're wise about if and how you use a proxy. If you have further questions about that evaluation process, make sure you ask us, right? We want you all to be successful in this. It is a bit more complicated than a typical eBay auction, but we've done the best we can to give you the business opportunity in the environment and time frame that we've been restricted to. So we wish you the best of luck. Thank you for your interest and support, and we hope you have a great weekend. We're going to sign off now. Thank you.